Welcome to eDiscovery Leaders Live, where I get the chance to chat with luminaries in eDiscovery and related areas.
Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am the increasingly hoarse George Socha, Senior Vice President of Brand Awareness at Reveal. And I am hoarse because, as you can see, we are here at ILTA this week. It is day 2 or day 3, depending on how you count. And I hope I make it to the next day without losing my voice entirely. But we are hosting eDiscovery Leaders Live special here this week with somewhat shorter segments, but a much larger number of guests. My guest for this segment is Damien Riehl, and I will let Damien explain who he is, what he does, and where he is. Damien.
Great. Thank you so much, George, for having me on. My name is Damien Riehl. I'm a product manager, direct manager for Fastcase, document alarm. So my day job is to be able to extract the DNA of the law and be able to feed it back, both law and facts, which we'll talk about in a bit. Before that, I litigated for 15 years for the Robbins Kaplan and worked for a couple of judges doing complex litigation, commercial litigation, patent law, and otherwise. As part of that, I started practicing in 2002 where I had concordance, and I, of course, moved on to relativity and had tens of millions of documents. So I have, both on the reviewing side and on the managing side, a lot of eDiscovery. Good memories mostly, with some sad memories on eDiscovery. After that, I worked for Thomson Reuters, and also relative to eDiscovery, I worked for Strauss Friedberg for a while. I was able to work both on the eDiscovery side as well as on the forensic cybersecurity side. The biggest thing that I worked on, Facebook hired me and my company to investigate Cambridge Analytica. So I spent about a year of my life on Facebook's campus in a eDiscovery forensics kind of role. After that, I moved to Fastcase, where I'm doing cool things that we'll talk about today.
And while I would love to talk with you about the Cambridge Analytica work, I don't think that can be a topic for discussion today.
Sadly, it cannot. There's lots of attorney-client privacy.
What I would like to do, though, is cover ground that we have not covered in any of the previous eDiscovery Leaders Live sessions. You mentioned that your focus is very much on the law of things. On my side of the microphone, on my side of the table, our focus is very much on the factual side. But of course, those two could come together. I'd like your thoughts on that. So with that open-ended question, proceed.
And with that simple question, we could have 2 days of very thorough discussion, but sadly we have 15 minutes. When I clerked for judges, of course, that idea of fact and law was very much thrown through and driven back that you need to be able to have the facts to be able to satisfy the elements of the law. If you don't have the facts to satisfy element 1, element 2, number 3, you fail and the law goes away. So the fact and law is inextricable. You need to be able to have both. But of course, as part of the law, it incorporates facts. You said that, for this thing, you need to show breach of contract, we'll say. We'll need to show that there was a contract. That is factual. That contract was breached. That is factual. That there was damages. That is factual. So the line between what is fact and what is law is not always clear, that there is factual elements within the law. And of course, through the legal elements, that will determine what facts you want to pull. Because if the fact doesn't matter legally, who cares? It's just gossip. It's only if the fact matters legally that it actually should be able to come into trial or come into the deposition or something like that. So while there are two distinct things, facts and law, I will say that there is a intermingling, and I think that we'll talk during this conversation about ways that intermingling can be able to, in a gestalt way, the whole can be greater than the sum of those fact law parts.
So that takes us to the question of today, the current state. Do we have that gestalt? Do we have the whole greater than the sum of the parts, or do we simply have parts strewn across the table, like so many poker chips across this table here?
That is such a great way to put it. Yeah, I think at this point we are scrambling in the dark for parts. I think we are looking for the poker chips without the light on, and we say, okay, here's a fact that might actually be relevant, but we're doing so in a rudimentary way. I think there's a very sophisticated way that I think that the fact and law can be merged, and one is to be able to say, for any cause of action, breach of contract, we'll say, the law says to prove breach of contract, you need to show these 4 things. And then for each of these, when I was doing e-discovery as a practitioner, I would create in relativity a bucket that said breach of contract, and then a sub bucket that said element 1, that there was a contract. I would say element 2, that contract was breached. Element 3, that there were damages. I would have those 3 sub buckets, and every time I would tell all of my reviewers, as you see something that goes to that element 1, drag it in there, because that is the way that we, at the end of the document production and at the end of discovery, I just do an export of all those things, and all of my Bates numbers form to my motion to dismiss or motion for summary judgment. That now I'm able to export these things to be able to, show that melding between facts that I found in the document and law that I knew as the elements, and bringing those together. That is the way that law should be practiced.
And that replicates, going back a generation earlier, exactly how things were done, except you didn't have virtual folders. It was a cardboard box with manila folders or maybe something bigger. And if you had a document, you'd make a copy and put it in one folder. If it was relevant to 2 folders, you'd make 2 copies and 1 in each folder. So that took you a little bit farther. Is that far enough?
That's probably not far enough. And I love that you say harken back to the old days, because I grew up in Robbins, Kaplan, Miller, and Cerisi. Of course, Mike Cerisi is a legendary trial lawyer. He said, start with the end. Start with the jury instructions, because with the jury instructions is what you need to get the evidence in. So the jury instructions are based on the elements of causes of action. So that's I love that you're harkening back. So is it enough to be able to put them in manila envelopes, was your question? And I would say that probably not enough, because the word. The words, if you do a keyword search, as everyone here knows, is not good enough. The conceptual search that Reveal does is a much better way. And so I know that very rarely in litigation, I did breach of contracts all the time, very rarely will a party say, I will herefore not perform on this contract, or I will herefore contract, right? But there are lots of words that express that contract, like not going to happen, period, right?
Yeah.
Reveal and Brainspace could be able to, and all of the other amazing things that you've done, can be able to say not going to happen is pretty closely correlated to non-performance, the breach of the contract. So I think there are rudimentary ways to, in the dark, find those poker chips, and there are much better ways to be able to connect those things.
So look then not to the past, but to the future. What sort of better ways could you envision?
I could envision that you could be able to go into a particular document and highlight that document and be able to say the words that you've just highlighted in that document, here are cases in the district you happen to be in that has those particular words. In that way, those facts in that document is connected to the law, that is the case law, is connected to motions in the district court that aren't necessarily appellate motions, but district court motions. That snippet of text in that document, you could imagine eliciting, displaying the case law that relates to that snippet of text. Not just the verbatim snippet of text, but the concept that snippet of text relates to. Then you're starting to magic.
So that even if there is not a single word in that snippet of text that actually shows up in that case law, you can still pull in the appropriate cases.
That's right.
And pleadings, right?
And briefs, pleadings, motions, orders, all of these are treasure troves of text that you can correlate the facts that you have in documents with this treasure trove. And I will say that my employer is Fastcase, which has a company called Docket Alarm. And a shout out to the Docket Alarm co-founder, Michael Sander. He has 500 million judicially filed documents and lawyer filed documents. And that is a pretty good data set for this side of it. So one could imagine taking these concepts and in that treasure trove of not just that a motion to dismiss, but the contents of the motion to dismiss, that concept, you can imagine saying there's a correlation between this concept and element 3 of breach of contract, and then you win your case, because even though the verbatim words are not in this case law, the concept is.
So let's take it the other direction. You are doing as Mike Cerisi, or in my case, it would have been maybe Mark Whitehead suggested, in writing the jury instructions before anything else. How could a structure like this inform you as to what your jury instructions ought to look like?
That's a beautiful question. So in Fastcase Docket Alarm, we have the docket alarm data set, which is all the court filings. We also have the Fastcase data set, which is not just judicial opinions, but we have jury instructions. We have rules of civil procedure, including the rules of discovery. And so we have all of the law, rules, regulations, statutes, case law, and many other facets that all relate to the facts. So one can imagine for a case that mentions performance, you can imagine just doing the reverse, saying, I highlight performance in this case law, element 2 of breach of contract, and then it goes to all the documents, not just the verbatim text, which you can have, but also the concepts, like say a word cloud or something, that here are the words that are associated with breaching performance. Therefore, it's essentially just the reverse of what we just said a moment ago. You can click on this, see all the stuff from this side, click on this, see all the stuff from that side.
So what other than things could you envision for the future with all of this?
I think that really we at Fastcase Docket Alarm are extracting the DNA of the law side. So we are pulling, we are working with the SALI Alliance, which I'm a primary part of, to be able to count 9,500 things within the law.
So let's stop here and just explain, what is the SALI Alliance?
I'm so glad you asked. I'm a member of the SALI Alliance, which is a nonprofit that is looking to standardize legal data. That is to be able to say, you are a thing called, you are using a thing called e-discovery, and we'll say a deposition, right? So a deposition is a thing. In all of our systems, Reveal has a thing in their system called deposition. I have a thing in my system called deposition, but your number is probably different than ours. What Sally's looking to do is to say, let's have a uniform standard that your number and my number, let's just use the Sally standard or map it to the Sally standard so I can communicate, my Fastcase can communicate with you at Reveal. So Sally's looking to create a legal data standard, nonprofit, to have 9,000 different things like deposition that are using the same language to communicate.
Is there anything magical about the number 9,000?
Is that a magical number? I'm not aware.
I don't know. Why 9,000? Is that just how many you have?
Oh, right. So we just happened to, last 4 months ago, we had 6,000. Now we have 9,000. Next time we'll have 12,000. So there's, we're building the DNA, we're mapping the legal genome. There will be many, many more.
So then, having mapped the legal genome, what can people do with that content?
So we at Fastcase, we acquired a company called Judicata that is currently, they can do magical things like be able to extract propositions, this thing is true, and citations, Smith v. Jones. Smith v. Jones says this thing is true. We've then been able to do that. Currently, we are then tagging motions and all of those 9,000 things, we're marching through them to be able to tag documents with those 9,600. So one can imagine that really smart companies like Reveal and Fastcase and otherwise can use that Sally standard to be able to do that join like we talked about earlier, to be able to say, here are the facts that matter, here are the Sally tags that for those facts, and here on the legal side, we'll just join those facts together and you can get some beautiful harmonics.
Yeah, it becomes the middleware, if you will, between the two.
That's 100%. Almost like the what kind of stone? Rosetta Stone between.
Yes.
Yeah. Mm-hmm. Yeah, it's really, I think that Fastcase is one of the most amazing companies I've ever worked for, and Sally is one of the most important things I've ever worked on, because it's with that AI happens. Because once you put a name to it, you can put analytics to it, you can do correlations between it, you can put graphs to it, the sky's the limit. But you need to know what the thing is before you can analyze the thing.
What is the status of Sally? I mean, you said 6,000, 9,000, 12,000. Is this a published, publicly available thing? Is this something in a beta form? Where's it at?
Sally 1.0 was revealed in, not revealed, it was released in January of 2020. So that was version 1.0. Sally 1.0 had about 1,500 legally specific things that we counted. Version 2.0 is going to be, it is now released. You can look it up today. We have now, like I said, 9,500 and some odd things. So we've gone from 1,500 to 9,500. That will become finalized next month. And then after that, we'll keep adding more. We'll add more e-discovery things.
What does it mean then, because you keep adding things, for it to be finalized?
Is the law ever finalized? There will always be new wrinkles to it. And I will say that we are exploring the human genome, right? The human genome, I think we've finished exploring it, but there was a while where we just kept on exploring until we reached the end. Maybe we'll get close to the end, but because the law always evolves, I think that the Sally will always rely.
Is Sally focused exclusively on the federal system within the U.S., covers states as well?
We have state courts, we have federal courts, we have federal causes of action, state causes of action. Version 1.2 got some criticism saying that version 1 was only for big law. I've taken care of that. I'm a do-gooder at heart, as I know you are a do-gooder. We have lots of people law things, so housing problems, eviction problems, my landlord-tenant thing. So things that we got criticized from legal aid organizations. Those are all in there now. I've also taken from the public benefit I forget the nonprofit that relates to legal aid organizations. They have a taxonomy that we've ingested into Sally, so there's a one-to-one connection between that. So short answer is no, we are not just big law, we are not just federal, we are all the things.
Well, it sounds like we are going to be seeing quite a bit from you in the months and no doubt years to come. Damien, thank you very much for joining us today. Damien Riehl is with Fastcase. I am George Socha with Reveal. This has been e-Discovery Leaders Live. Please join us again tomorrow morning at 10:15 Pacific as we meet with our next guest. Thank you very much.